Hi guys, welcome to my channel. It's your favorite lawyer Mojola Lua on the beat. May please the court OM Livingstones for the plaintiff. The plaintiff in this case is a landlord or a property owner. If this is your first time on my channel, kindly subscribe to my channel, like my videos, leave me comments in the comment section. Let me know how useful you found the video you've watched and what you'd like me to talk about on the channel. Please share my videos with your friends and your foes. Spread the word. Thank you. And please do turn on the notifications so that you would always get a notification whenever I drop a new video. Thank you. So a few weeks ago, a friend rang me up and he was asking me about ejecting a tenant that has refused to leave the property even after the expiration of his tenancy. So according to him, this person has not been on the property for 3 years but has put the shop under lock and key. So he wanted to know if there was a legal remedy. I really appreciate the fact that he made that inquiry because I know that most Nigerians will take laws into their hands and probably break down the door, to re-enter forcefully. But I also assume that this is because many people do not know that there's a provision of the law as regards this. The law has made provision for a landlord or a property owner to recover their premises after the expiration of the tenancy from a tenant that has refused to let up possession. So, tenancy is a binding agreement between a landlord and a tenant. Before this, they are merely property owners and a person intending to take up the possession of a property. But upon signing tenancy agreements and payment of rent, they become landlord and tenant. Usually they have duties and responsibilities one to the other, and they have rights and covenants during the pendency of the tenancy. And there are different types of tenancy, but let's use the example of a yearly tenant in this case. For a yearly tenant, there are several ways by which the tenancy can be determined. But let's talk about a fluctuation of time. For a yearly tenant, the tenancy would determine at the end of a year if it does not renew. But if it renews, the tenancy continues for as long as he and the landlord want the tenancy to continue for. But in the case where a landlord does not intend to continue the tenancy, he can issue a quit notice. Now, I'm not going to go into the different reasons for which a quit notice can be issued, but let's just take the reason of a landlord wanting a tenant off and out of his property, trying to recover possession. To recover possession, he issues first a quit notice. Now, for a yearly tenant, which is our example in this case, a quit notice for a yearly tenant is 6 months notice. A yearly tenant must be given at least 6 months notice to leave the property before it can be evicted. At the expiration of these 6 months, he must have left the property or might have reached an agreement to continue the tenancy, to renew the tenancy, maybe on some other agreed terms with the landlord. But usually, a yearly tenant is entitled to 6 months notice to quit by his landlord or the landlord's agent who has a written authority from the landlord to issue the quit notice. This notice must be 6 months, exactly 6 calendar months given to the tenant to vacate the premises. Now, many tenants make the mistake of thinking that because they've been given 6 months notice, they won't pay for those 6 months. That's very wrong. The law is going to be fair to both the landlord and the tenant. So while the law understands that, as a tenant, you might not have an alternative arrangement for your accommodation or for your store or your business or anything, the law is giving you 6 months to find an alternative or to sort yourself out, as the case may be. Now, the law will not allow the landlord to suffer for those 6 months. So while the law is taking your convenience into consideration, it's taking the landlord's profit into consideration as well, because the landlord spent money to develop the property and is entitled to gain over his property. So if you've been given 6 months notice or any month's notice, depending on the type of the tenancy you're holding, you have to pay for those months. I know that one day someone called me and they were like, oh, the landlord gave them quick notice and they spent some time during the they spent some time in the period of the quick notice, and then they've left the property, and now the lawyer is chasing them for payment for the period of the notice which they spent on the property. And they expected me to tell them that they're not going to pay. I had to tell them that actually you have to pay. The landlord is entitled to recover rent for those months that you spent on his property, even if they were within the period of a quick notice. So even if you are being given 6 months notice, you will pay the rent for those 6 months. The law will not allow you to enjoy at your landlord's expense. Okay, so after those 6 months, the next thing for a tenant that has refused to let up possession, to give up possession, the next thing is for the landlord to issue a notice of intention to recover possession. This notice of intention to recover possession lasts for 7 days, 7 clear days. Note that for the 6 months notice, quick notice, it's clear calendar months. But for notice of intention to recover possession, 7 clear days must be given to the tenant. And you will also pay for that period too as a tenant. Don't even think that anything is free. So after those 7 days, if the tenant still refuses to give up possession, the landlord can now go to court and commence by way of a writ, commence an action to recover possession. If the action is successful, the court will issue a warrant of possession to the landlord, after which he can enter the premises by any justifiable means and recover possession. So that's for a tenant that's still on the property. Now, many people do not know that this also applies to a tenant that is not on the property, but who probably has his goods, his property, his personal effects in the property under lock and key. Because for a tenant to deliver a possession to the landlord, he must deliver unfettered possession. That is, he must deliver full possession to the landlord. The landlord must be able to re-enter his property and use it for what he sees fit. So in cases of tenants who just disappear and then they've locked up the property, the landlord cannot enter, the landlord cannot do anything useful with the property, the law also has provisions. Sometimes those properties are called abandoned properties. So the provision of the law is this. For instance, we're using a yearly tenant as an example. When the tenancy has expired and the notice period has expired and the tenant has not paid rent, has not renewed their rent, they move from being a yearly tenant to becoming a tenant at will. That is, they are now a tenant on the property at the will of the landlord. In that case, they are no longer entitled to a notice to quit, but to a notice of owner's intention to recover possession. So don't get it twisted. Let me re-explain. Normally for a tenant, a yearly tenant, 6 months quit notice is issued. If they refuse to give up possession, the landlord then issues a notice of owner's intention to recover possession, which lasts for 7 days before it proceeds to court. But in the instance where the tenancy has expired and the landlord did not issue a quit notice or anything, but the tenant has not paid his rent, for a yearly tenant, for instance, 1 year has expired from when they last paid rent, and the landlord has not issued a notice to quit, and they have not renewed their rent. In that situation, they have moved from being a yearly tenant to tenant at will. That is, they are now occupying the premises at the will of the landlord, and the landlord can decide to evict them at any point in time. In that case, if the landlord suddenly decides to evict them, he will not need to go by a notice to quit first. He just needs to issue them a notice of owner's intention to recover possession, which lasts for 7 days, 7 clear days. After those 7 days, he can proceed to court by way of a writ to recover possession. Now, where the tenant has put the house under lock and key and has gone for like 3 years, as in the instance that my friend called me about, his tenancy has expired, his tenancy has lapsed. He is no longer a tenant. He is now an occupier of the premises, and the landlord is now an owner of the premise and no longer a landlord to him. Therefore, all the landlord needs to do is to issue a notice of owner's intention to recover possession, which lasts for 7 days. Now, you'd wonder, how will it be served? Because service is very crucial in this matter. For quit notice, it must be duly and properly served. Same thing for notice of owner's intention to recover possession. So where the tenant is not around, it's not available, you can't trace him, he's been gone for 3 years, as in our scenario. What the law allows is that the notice be pasted on the premises in a conspicuous place, and then pictures can be taken of the notice and presented to the court as evidence of proper service. The notice must be served. Same thing with quit notice. Even where the tenant is evading service or where it cannot be found, cannot be traced, cannot be served, the notice can be pasted on the premises. The same thing that goes for residence goes for business premises in this case. If the owner of the business or the tenant in the residence cannot be served, if it's completely impossible to serve them, the notice can be placed on the premises in a conspicuous place, and evidence adduced to the fact that it was actually pasted. That would suffice, and then the owner can proceed to court by way of a writ to apply for an order of repossession of the premises. Where this order is granted, the owner is entitled to re-enter the premises by any justified means, which means he can break down the door, he can re-enter. So it's very important to go by way of the law so that there would be no unpleasant aftermath. Many people don't know this, so they go by way of force, by way of self-help. It's not the best. It's better if you have a court order to go ahead and re-enter the premises than entering the premises by yourself. So that's all I have for you today. I hope you learned something. I hope you found this useful. Please leave me comments in the comment section, like my video. Please subscribe to my channel, turn on notifications so that whenever I drop a video, you will be alerted and you can watch.